in listen-only mode.
Good afternoon, everyone. This is Jennifer Schaus coming to you live from Washington, D.C. We are in the third presentation of our webinar series for 2016 covering various topics in government contracting. Today we are fortunate enough to be joined by David Dempsey, who's going to be covering teaming agreements and the good, the bad, and the enforceable. So we will here's the list actually of all of our webinars that are coming up. They are all complimentary and they will all be recorded. So if you happen to miss one, you're always welcome to download the audio for that. Our agenda for today, I'll tell you a little bit about myself. David will share some background information about himself and the law firm that he works with. We'll dig into the presentation, final thoughts, and then any questions that you have, you can type in on the right-hand side. You should have a control panel, and we will answer your questions in the order that they're received. In the event that we run out of time, you can contact David directly, and he'll be happy to answer your questions there. We do have a full hour. However, the presentation shouldn't take that length of time, so feel free to type in as many questions as you have, and again, we'll use the allotted time to answer those. So again, thanks for joining us. A little bit about myself. I've been in government contracting almost 20 years. I started my career with Dun & Bradstreet, working in their government division and selling credit reports to the government agencies, including GSA, contracting officers across all agencies, and then some of the intel agencies that were using the Dun & Bradstreet data to conduct the white-collar criminal investigations. I then worked for some other companies, both large and small, variety of industries, helping them with federal sales and GSA schedules. And since then, I guess for the last 10 years, I've had my own consulting firm based in downtown DC. We help government contractors with anything from proposal writing, GSA schedules, some of the certifications, and we also host events for government contractors, primarily at the Kennedy Center. We've been doing that for about 8 years, and we pull in roughly 250 government contractors, as well as federal agencies, and typically somebody from the OSDBU, which is the Office of Small and Disadvantaged Business Utilization. So enough about me, and let's dig into the presentation here with David, and we'll hand the controls over to him and let him tell you a little bit about his experience and himself. David, it's all yours.
Thank you, Jennifer. Good afternoon, everyone. I appreciate you taking some time today to listen to this material on teaming agreements. It was actually sort of difficult to put together given the changes that have occurred in the last 4 weeks, but I'll be discussing those. I've got 39 years of experience in government contracts, so I guess you could call me a recovering government contracts lawyer. The experience goes everywhere from litigation to writing regulations in the DFAR and the FAR. What I've got on the slide here is experience for formation, administration, litigation of government contracts, and I've done this in Europe as well as the U.S., but clearly 95% in the U.S. And then I focus on IT contracts, service contracts, a lot of small business issues, accounting, and IP rights are sort of a subspecialty of mine, and then export controls. And the firm now, Dempsey Fontana, is made up of myself and Jim Fontana and a couple of others that we have here in the office. And we basically two fellows that got tired of our respective environments. Jim was a in-house counsel for many years, but he's got about 30 plus years of experience, and I've got 39, and we focus on providing value. We've got as much experience as any large firm does, I think, and I'm confident when I say that. But we don't have the overhead that large firms have. And I'm very confident when I say that. So we're essentially trying to provide a good value to companies. Now, with respect to the presentation, the context that I've putting this in is procurement. And it may sound kind of obvious, but I'm talking about procurements where there's a large program for an IT buy, for example, weapon systems or services, and the team leader or the prime contractor needs peculiar expertise, peculiar past performance, and therefore that prime has to put together a team of subcontractors. Whether it's one or not it depends on the procurement, of course. And then with respect to small businesses, a lot of times, as you know, small business subcontracting is a significant evaluation factor. I've got this in the context of the normal sequence of events, which is a non-disclosure agreement, occasionally a memorandum of agreement, the teaming agreement, and then the subcontract. In my estimation, the non-disclosure agreement, or the NDA, is the foundation of the teaming agreement because it will identify what role a sub will play as determined by the information to be exchanged between the parties. And I'll be going into that non-disclosure agreement in some detail. And then each party needs to protect its intellectual property and or trade secret and proprietary information, which generates from the non-disclosure agreement. Now, the memorandum of agreement I've got listed is a interim step that happens when a large procurement, usually and almost frequently in the IT area, the government announces it's going to do XYZ of billions of dollars, but they don't know when they're going to release an IP, but people start to get together. It's too late to, it's too early to form a teaming agreement. It's too early to start exchanging data because you don't know what the government's going to do. So you sign an MOA, and that would be definitely a non-enforceable agreement, just a sort of intent, or as the phrase you'll be hearing, an agreement to agree in a future event. And then the teaming agreement itself, I've counted over the years 30 to 50 different terms in a teaming agreement. Everything from definition to responsibility to flow down clauses to duration and termination of the agreement, non-compete, non-hiring of personnel, organizational conflicts of interest, classified information, export controls, indemnification disputes. All that sort of thing is not what I'm going to talk about. I'm going to be talking about the enforceability. However, I'll take any question on any teaming agreement related subject that you may have. And then the last element of the context here is the actual prime sub relationship executed in a subcontract. So that is our context. And if we go to the next provision here, the next slide, this is where I begin on the non-disclosure agreement. And there's a lot more here than I would have liked to have happened, but as you'll see, a lot of things have happened. I've got this first rule, sort of like the doctor's rule, do no harm, but in this case, do no harm to yourself. And that is make sure you do what you can in the non-disclosure agreement to protect your intellectual property and or your proprietary data. On June 15th, a few weeks, the FAR clause that came out on May 31st requires a system of security controls, and this is part of the cybersecurity wave going through the procurement process. Normally in teaming agreements and in the non-disclosure agreement, the obligation is that each party will treat any information they get from the other party as they treat their own, safeguard it, etc., that sort of thing. Well, for the first time, this clause in subparagraph B provides essentially 15 elements for safeguarding information that is on a contractor's information system. So my estimation is worth it to incorporate what will be FAR 52.204-21B into the NDA, because if you're dealing with government contractors, they have to have a system anyway. So what you want to do is make sure that any information that you provide goes into that system that has these minimum 15 elements per safeguard in it. And that way you don't have to actually ask yourself what system do they have where they protect my stuff as much as their stuff and vice versa. Then you'll know what they have. And that, I think, is going to be quite useful to you. Now, the second element in the first rule is markings. And this is markings of data that you provide in the NDA stage. And there, I think what you should focus on is you use trade secret or proprietary data markings. And don't say confidential information or that sort of stuff. Say proprietary information of so-and-so company or trade secret of so-and-so company. And trade secrets are the obvious things, such as prices and your labor classifications and whatever you may have related to the particular procurement. But the proprietary nature is essentially anything you give them, and then the definition of confidential information is going to be whatever is marked. So in the NDA, you want to take a little extra care and make sure that when their definition of confidential information is provided, that you add to that confidential and proprietary information or trade secret information, collectively known as confidential information, is whatever's marked. And then go ahead and do it with respect to the exchange of information. As I was saying, a lot of things have happened in the last few weeks. One of them is the new Trade Secrets Act. It's Public Law 114-153. It's called the Defend Trade Secrets Act of 2016. It was signed into law on May 11 of this year. And what it does is it gives a private right of action to protect the trade secret at the federal level, which has never been the case before in the United States. Up till now, it's always been trade secret laws, or the Uniform Trade Secret Act, adopted by each state. And as a practical matter, there's 47 states with trade secret laws, and 2.5 without. The half is North Carolina. The 2 are New York and Massachusetts. The relevance, though, is now you have, I recommend, you put in this non-disclosure agreement that anything marked is subject to the Defend Trade Secrets Act of 2016, because you will then, for the first time, have a private right of action, which you've never had at the federal level. And then on May 21, for those of you involved with classified information, this is similar to the FAR clause, but the NISPOM was changed. The National Industrial Security Program Operation Manual was changed to establish a what's called an insider threat program, monitored by an insider threat program senior official. And of course, DSS, or Defense Security Service, cannot talk in language that we're accustomed to. Everything is in a all caps abbreviation. So this is the ITSPO, I guess. And the ITSPO, this is the Insider Threat Program Senior Official, can also be the FSO. It's a Facility Security Officer. And depending on the size and scope of your classified programs that you're working on, that will depend on the size and scope of your insider threat program. And all of this is set out fairly straightforwardly in the NISPOM Change 2, which came out on May 18th. Point I'm making here is that if in the due diligence, something I'll be getting to in a minute, see if your company that you're dealing with, is whether you're prime or a sub, as classified contracts, because if they do, they're not only going to have the requirement associated with the FAR that I just mentioned, but they're also going to have this so-called insider threat program that they're going to have to do. And I don't know if you have to put that in the non-disclosure agreement, but it should help you with respect to assurances that your information that you disclose to them is going to be worked out, handled in such a way that you can be confident that it won't be used without your knowledge. And that's another element of the NDA, is make sure you know what you're providing that information for, who's it going to go to, who's going to exchange, who that person, the single point of contact, is going to provide it to. Specifically confirm that you'll find out if it's going to go to a third party. And in other words, just pay attention. I bring this up because just 2 weeks ago, in a non-government procurement circumstance, a friend of mine explained that they had signed an NDA was from biotechnology, and it's one of those firms that's pretty good on biotechnology, and they found out 6 months after they signed the non-disclosure agreement that the company they had given their information to had come out with a new product. And I asked him what his NDA said, and it said a bunch of things that are not particularly useful to someone whose intellectual property was stolen from them. So now we've got on the next slide here, I've got this purpose of the NDA and the teaming agreement, and as you can see, I'm putting them together now. I've mentioned the collaboration. Some people refer to government contracting as a team activity. I'm not sure I'd go that far, but for a big program, it certainly is. And in the memorandum of agreement, if you're going to use that interim step, you still want to identify what the contributions are going to be. And in particular, you want to set forth exactly what's going to be in the proposal in the MOA and or the teaming agreement where you are. Because past performance experience and key personnel are a particularly useful element in the evaluation. And of course, if you're a subcontractor who has better contacts with the government than the prime does, then you want to make sure that you are identified in the proposal. And then also you want to make sure that the work that you're going to be doing, and this is either in an MOA or a teaming agreement, with a teaming agreement being much more specific, is the type of work you're going to do and the percentage of the work that you're going to do, because those two particular factors are extremely important when it comes to trying to enforce the teaming agreement. And enforcing the teaming agreement, I'm talking about an ability to have a court direct the prime to give you a subcontract, because that's the purpose of doing this this entire procedure, is to get that subcontract. Now, with respect to teaming up with somebody, I think what the court decisions have done have given people an opportunity to figure out if they want an enforceable teaming agreement or an unenforceable teaming agreement. So you're going to have to do some due diligence, and I think from my perspective, it's due diligence on both sides, not just due diligence on the prime, but the prime should be doing the same with a subcontract. And of course, the first thing to figure out is, best you can, is the other party a jerk of some kind, and that would be, what's their reputation of the company and what's the reputation of the person you're dealing with. In other words, two elements of normal due diligence from my perspective. And then the other normal due diligence is the Google searches and the SAM searches, and you ask them about potential organizational conflicts of interest. You may as well ask. I don't think you get an answer, but you should also ask about any disclosures of the ethics issues that they've had, any issues associated with the DCAA audits and that sort of thing. What you'll get as an answer, I don't know on some of these things, but I think it's worth it to ask. Now, another element of due diligence, at least that's where I'm putting it here, are the changes to the SBA rules that came out on May 31st, i.e. Monday. And I'll go over a couple of them because they're going to affect a teaming arrangement. First one is recertification. If you're a prime and you're trying to get a bunch of smalls to team up with you, excuse me, a large prime trying to get smalls to team up, you have to make sure that they are small throughout the intended subcontract period or prime contract period. But SBA says that if in the merger or sale area, if the merger or sale of a small comes after proposal submission but before award, then the small must recertify. And that's not the case now. That's why I mentioned it to you, because you want to put that in the teaming. There's also issues associated with affiliation. SBA has clarified identity of interest, which is essentially family members conducting business with each other, and whether or not, because of family businesses, multiple businesses, multiple family members, where they all are going to be added up in such a way that they're going to exceed the NAICS code employee or dollar value number. Another one is clarifications on economic dependence, where someone does a lot of business with somebody, i.e. the prime and a sub, such that the small business is economically dependent on the large business. If that's the case, then SBA will say that you're affiliated, and therefore you add up the two businesses, and the small will no longer be a small. And then there's, I think, probably the most significant change with respect to small business teaming agreements, which then elevate to a joint venture. And there's not much of a difference between a teaming agreement and a joint venture under certain conditions. And one of them was when two smalls join up to go after a procurement. They can do that without being affiliated under current rules, but now the rule changed so that two smalls can joint venture on a subcontract so long as both are small under the NAICS code. And the prior rule was they had to be both small under the specific NAICS code, but the procurement had to be greater than half the size standard if it was receipts-based size standard, and if it was employee-based standard, the procurement had to be for more than 10 million. So now there's much more ability of smalls to joint venture together than there have been. There's no more restrictions associated with the procurement itself. The biggest change in these new rules for small businesses, and this goes to the 8A, service disabled, veteran-owned business, hub zone, women-owned small, and the economically, well, women-owned smalls, all the women-owned small businesses, is the similarly situated subcontractors, and this goes to the limitations on subcontracting provision, or the amount of work that the small has to perform as the prime or as a joint venture. And similarly situated, what that means now is that if you have two 8As and they're combining to go after a procurement that's a 8A set aside, then they can combine, and all the work they do is not going to be limited. It's not going to be affected by the 50% rule, which we go by. And that rule is also changed. It's no longer 50% of the value of the labor involved. It's 50% of the amount of money paid by the government. So that's a greater number. So you have to look at that, these new regs when you're getting involved with a small business as a subcontractor, or when two smalls are going to try to get together for purposes of going after a set aside. I'd like to go into more detail on that, but that would be quite an explanation. So now I'm finally turning to enforceability, and this is where you want to enforce the expectation that if the prime gets the contract, you're going to get a subcontract. It may seem obvious, but that's where all the litigation has been. So I'll go back to the question I've mentioned earlier. Do you want the agreement, the teaming agreement, to be enforceable? If you do, then you want exclusivity. And if the exclusivity is agreed to and the NDA is executed the way you want it to, then it may be best just to forget a teaming agreement and award a subcontract, or start working on a subcontract together, so that you're past the teaming agreement stage and you're actually negotiating and going to come up with an enforceable subcontract. And if you don't want to be with a specific prime, and this could be for any number of reasons, you want to sign up with several teams on a non-exclusive basis, and then usually there's not much intellectual property involved in this kind of circumstance, at least my observation. So you just send in your prices, schedules, labor classifications, if it's a service contract, and what you're going to be doing for an IT contract, that sort of stuff. Send it in marked appropriately, and it's marked, as I explained earlier, in terms of trade secret or proprietary information, and it's not marked according to the FAR or the DFAR legends. Those legends are for the government, and you don't want to mark information to give to a prime contractor in such a way that you're reserving rights to the government and therefore reserving rights to the prime. You want to make sure you can use the Defend Trade Secrets Act against the prime until you come to a deliverable under a subcontract. Now, with respect to enforceability, I've got 4 court decisions listed on this next slide. They are CyberLock, X Technologies, Inc., Advanced Telecom Process, and AT Solutions. And each one of them basically comes to the same conclusion, which was with respect to giving the subcontractor a winnable argument that it had a contract where it would receive a subcontract if the prime was successful. These decisions would all say, although the decisions were not exactly on point with respect to what I just described, they said, the court said no. You had an agreement to agree. Principally what you had was the language which is common to all teaming agreements now, is if the prime wins, if prime is selected, the parties will agree to enter in good faith negotiations for award of a subcontract. And if they can't agree on price, then something else happens. That language will immediately disqualify you from a enforceable teaming agreement. This is essentially what CyberLock Consulting did, and that was an Eastern District decision down in Alexandria. It was appealed to the 4th Circuit in Richmond, and the appeal was denied. In X Technologies, we have a nuance that needs to be described to you. This is a 5th Circuit decision out of Texas, and here the teaming agreement was breached. The exclusivity provision was breached before award of the prime contract was made. So that issue was never discussed. The importance, though, is that the exclusivity term was clear. So when X Technology sued and had a jury trial, the jury found that, in this case, Marvin Test Systems had violated the exclusivity provision in the teaming agreement. So now you see a difference in the teaming agreement where you have a explicit agreement that's black and white, and parties will be exclusive with each other in the pursuit of this contract, versus the parties will agree to negotiate something in the future in terms of a subcontract. So when Marvin decided to put in its own offer, the jury found that it was a no-go, that they shouldn't have done that, and excuse me, X Technology was awarded damages and that sort of. With respect to Advanced Telecom, I'm bringing that up because that's a Maryland decision. 2015. First of all, the court there agreed with CyberLock analysis above, where the specificity of terms was insufficient to require a execution of a subcontract. And again, that particular agreement talked about a framework to negotiate a subcontract. And again, there was no mutual intent as to very specific terms that would give the court something to enforce. Now, AT Solutions is, as you can see from the date there, this was January 2016. And this was a decision where the judge ruled from the bench, so there's no written decision. You even have to look at the transcript of the proceedings that day. And what this judge did, and Eastern District in this case, this was in Richmond. The first one was Eastern District in Alexandria. This one is in Richmond. And that judge said, CyberLock controls, so you need specificity of the agreement to give the court something to enforce. In this case, the teaming agreement said that if the RFP was canceled, then the termination provision of the teaming agreement kicked in, and that was gone, and you know, the teaming agreement was no longer viable. And what AT Solutions thought was that that's not correct, because the government then reinstated the RFP, but R3 Strategic went ahead and teamed up with someone else. And that was something the court said, sorry, the termination provision of the teaming agreement was very specific, and it happened, teaming agreement expired, you can't resurrect it for purposes of trying to get a subcontract. So now what we've got from these decisions is essentially 9 points. This is the next slide. 9 points that you want to have in your teaming agreement if it's going to be enforceable. And first one is mutual intent, is that the teaming agreement, the intent of it, the objective of it has to be clear. As a practical matter, when you're drafting teaming agreements or looking at the draft that someone gave you or going on the internet and getting a teaming agreement draft, you want to put the mutual intent, the stated objective, etc., in the body of the teaming agreement, not in the whereas clauses. Whereas clauses are considered precatory, a nice way of saying nonsense, and they're not enforceable. If you think about the teaming agreement you have, it says whereas, 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 and it says, and therefore the parties agree. So anything above the parties agreeing is, you know, nice, but irrelevant. So anything associated with the objective of the teaming agreement, the qualifications of the parties, etc., should be in essentially Article 1 or Section 1 of the teaming agreement. And then you want the teaming agreement to specifically state that if the prime wins, the prime will or shall enter into a teaming agreement. We're not going to negotiate it. We got it. Condition precedent occurred, i.e. the award to the prime, and contracts with a condition precedent are enforceable. And so to make it enforceable, you have to go into the details. Now, the number 4 there is price terms. That's the easiest. And the second is the work share. What is the subcontractor going to do that the subcontractor wants enforced by the court, so that the subcontract anticipated by the sub gets the work share that he wants. When that happens, then you have a much better chance of getting a teaming agreement enforced. And if you all think about your own experiences with teaming agreements, very rarely does anyone sit down and say, we got to talk about the enforceability of this agreement, because you're always talking about, you know, the other elements that we talked about earlier, you know, the proposal responsibilities, prime sub responsibilities, definitions, et cetera, et cetera. You're not thinking about enforceability. Now you have to think about enforceability. And these 9 elements here, most if not all of them, will get you an enforceable agreement. You know, one thing is to identify in a proposal a subcontractor and the past performance of a subcontractor. Most teaming agreements will say that the sub will be identified. don't sign one if it doesn't say that, if you want it to be enforced. And then on exclusivity, to be specific in terms of these court cases as well as the negotiations that you're going through for the teaming agreement, you want to be exclusive for a particular work share identified in the exhibit or attachment to the teaming agreement. So make sure that if you're going to be exclusive, if you want to be exclusive, but be exclusive for something else, because for something specific, because that will tell the court, if you have to get it enforced, what you want to do. And let me make an aside here also. When you're in the disputes clause, all the bigs will want an arbitration provision, and they want that because arbitrations are essentially confidential. You can, under the American arbitration rules, you can ask for a decision yes or no, or a decision with no explanation given. And the large company lawyers in-house or outside counsel will know that. And in terms of expense, a serious arbitration is not particularly less expensive than a serious court case, except the arbitrator cannot enforce discovery or exchange of documents between the two parties. So I'd always suggest that you do not agree to arbitrate, that if you can't mediate a dispute under the teaming agreement, that you then go to court. Now, if you're thinking like that, if you're going to go to court, be ready to go to court, which means have the terms, etc., in the teaming agreement in such a way that the court has something to enforce. And then, to some extent, this was a case on the other side of the country, Ohio, I believe. The termination provisions have to be pretty strict. For example, if you agree that the teaming agreement expires if the RFP is canceled, that's fine. Just be ready to live with it. But you're not going to. You don't want to put a provision that says it can be unilaterally terminated by either party, or it has to be mutually done if it's after a year or something like that. You want to make sure that termination provisions are sufficiently restrictive. And then if you could get it, and this is not likely, I don't think, but it came up in this particular case, a liquidated damages provision that if someone terminates the teaming agreement improperly, they have to pay him X amount of money, which is essentially proposal costs plus whatever the liquidated damages would be. And then most of the time, you're going to have a pretty good idea what the subcontract terms and conditions are going to be, because they're essentially going to be flow downs from the prime. So attach those conditions to the teaming agreement, either as conditions that you know you'll live with, or conditions that you're willing to live with in the event you get the subcontract. And then there's, instead of a teaming agreement, you can do the GSA's contractor teaming arrangement, which is essentially two primes, is the way GSA describes it. So that's not a teaming agreement. It's not a subcontract either. It's just the arrangement that GSA has, where both parties submit proposals and perform according to their GSA schedule prices and whatever their GSA schedule says. Or a joint venture agreement, which is a teaming agreement plus, but it's not quite a subcontract because the joint venture has not been awarded a subcontract. So the split of work, prices, et cetera, that are in the joint venture agreement would be enforced as a matter of the joint venture agreement, not as a matter of a teaming agreement. And then if you really want this teaming agreement to be enforced, don't have any language regarding non-exclusivity. Don't have any language that says you're going to negotiate in good faith. And if you can't reach price, then you're finished. The termination provisions I've already gone over. And then there's a bunch of little things here on the termination about agreeing on price, government disapproval. I mean, don't go along with that. And I don't know where that started, but if government approval of sub is required, that'll be in the solicitation. So don't you go green to it one way or the other. Unilateral withdrawal and award of a subcontract is frequently identified as a means of terminating the teaming agreement. But I would say let the subcontract, let language in the subcontract terminate the teaming agreement, because you may want other provisions in the teaming agreement to stay in the subcontract. And then with respect to duration, you don't want the teaming agreement to expire after a year, 18 months, or whatever. You want it to go indefinite until both parties essentially agree, and that would usually occur when the prime contract is not awarded to your prime contractor. So the conclusion is pretty straightforward, and that is review all your existing NDAs and teaming agreements and see if they're consistent with the information I've provided, so you can figure out where and how you're going to amend these things. And then if you're able to do so in a particular circumstance, evaluate whether you want to do the contractor teaming arrangement on the GSA schedule or a joint venture agreement, which is frequently the case by some of the agencies looking for joint ventures other than a teaming agreement. Okay, so I'm finished. I went far more than I thought I would. And question then is there any, my question to you all is whether any questions from you all. I don't see any at the moment.
Great. Thanks, David. It was outstanding information on teaming agreements. And we do have a couple questions that have rolled in. One is asking, is there any way to print the slides? We record the audio and the slides together, so if you want the slides separate, you can email David and we'll have his contact information available shortly. What is the biggest mistake that companies make in contractor teaming agreements?
That's pretty straightforward, fortunately, and that is having, in terms of enforceability, that's having language that says, upon award of the prime contract to the prime, the parties will negotiate in good faith a subcontract. Once you do that, you're done, as near as I can tell, unless there's a lot going on that is not captured in the case law. And one of those activities would be if you are the prime gets the contract, you guys enter into negotiations for a subcontract, and it's taken a long time. But while you're doing that, the prime is giving you task orders to complete. And if you do that, then you've got the specificity associated with pricing, you got specificity associated with what work you're going to be doing. So that gives the court a course of performance to enforce, and there's actually a 2002 case on that, and that was by a state court in Virginia. But it was only a good piece of legal analysis because there was almost a year of performance by the two companies. So that gave the court something to enforce. But otherwise, a language that says you're going to negotiate will almost certainly put you in a position where you cannot enforce a teaming agreement. Is there anything else?
Great. Yep, a couple more coming in. As a small business, am I able to have two teaming agreements with two different primes when the RFP is out, hoping that one or the other will eventually win?
Well, the answer to that is yeah, you can have two teaming agreements. Presumably, neither one of them is exclusive because if it is exclusive, it's going to, the prime is going to insist on that, which means you can't compete against the prime on anything else. I shouldn't say regularly, but I've seen more than a couple of times an RFP provision where the government says it's okay for subcontractors, small business subcontractors, to team with various primes. And in those circumstances, if you have a teaming agreement that says you will perform such and such work at such and such prices according to your schedule, whatever labor classifications are involved, if that's relevant, then I would say that if you're going to have two teaming agreements in this hypothetical you're talking about, that would be enforceable. Don't know for sure, but that would certainly be my initial analysis based on this on these cases and and the provision in the RFP I'm talking about.
Okay. Another one here, teaming agreements for IDIQ type contracts are hard to identify work share. How do you suggest a sub negotiate with a prime with 15 to 20 subs to identify an enforceable work share?
I should have gone over that. I'm sorry I didn't. The Maryland case that I talked about, which essentially adopted the CyberLock case, was an IDIQ contract. And I asked myself the same question because not only is the IDIQ a problem with the statement of work, but it's a problem with the prices. And my answer, which is at this point an acceptable answer, but I don't know if it's going to be an enforceable answer, is that the work that you're capable of doing, that the subcontractor is capable of doing, be identified in the teaming agreement. And if you have to attach the entire SAL in the from the RFP to the teaming agreement, then do so. And then you're going to have circumstances on the IDIQ part, and this is frequently an IT or a service contract, you're going to have labor classifications and hourly rates such that they attach so that position, if called upon by the prime, would go to a specific part of the work statement to be performed. So there'd be a logical correlation or nexus, as the lawyers like to say, between the specific work to be done and the price for which that work would be done by the sub, and therefore, in terms of enforceability, the court has terms to enforce and can go ahead and tell the prime that if you're going to have a subcontract with this person, it's going to be for these prices, and unless you otherwise agree, and for this work statement. But the IDIQ part is the most difficult procurement circumstance to have a enforceable teaming agreement because of the uncertainty associated with the procurement itself. Another thought I had on this was the evaluated prices. The government will evaluate prices given by the prime, and of course the government says that this may not be what we actually order, but it still gives the government an opportunity to evaluate pricing, and I think if that could be properly explained to a court, the court would see that that is the only condition which you could put prices in, and therefore might give the company, might give the court the ability to enforce the subcontract for the company. But also, most of this stuff is going to be task order stuff, which is it's a contract, but it's kind of a step below the contract that the teaming agreement decisions encountered, except for this one in Maryland, which was a state court.
Okay. Last question here, how can a sub negotiate successfully with a bigger, more powerful prime?
there's only one answer to that, and that's the L word, which is leverage. If you don't have any leverage, I don't think you will be able to. You'll just take what the prime does in the teaming agreement, and then if you do, then you can go ahead and get the teaming agreement text that you want. And then the third option, which a client of mine did last week with General Dynamics, was says we don't want to deal with it. We just don't want to deal with it because we know you're after our intellectual property. And that was the end of it. But they're, after all the legal stuff and the judges' decisions and all the law review articles and stuff, the other most significant element to teaming agreements is, I think, leverage that one party has or does not have with respect to the teaming agreement discussions and or negotiations. Apologize that I didn't mention that during the prepared remarks, but it's I guess asking a question now and at least getting my answer is you're getting a straightforward answer.
Well, great. Fantastic presentation, very thorough answers, and good questions from the audience. So thanks again, David, for your great insight into teaming agreements, which are very common these days. And thanks, everybody, for taking the time out of your day to join us. The audio recording will be available early part of next week as we continue our webinar series. We've got a full week next week and 4 presentations the week after. So again, if you're not able to join us for any of those, you can certainly tune in for the audio recording. And again, thanks everybody. Any last final thoughts, David?
No, I don't. I'm tired of talking right now, so I don't have any more final thoughts. If you have any questions, just take the take email and send them to me. I'll see if I can get you a quick answer.
Super. Okay, we will conclude our presentation now, and thanks everybody for joining us.